Hi folks. In this video I'm going to run over uh, chapter 7 with you. In class I've gone over this chapter but very briefly and in a summary way. And I think that some of you would probably prefer a little briefer, a little more detail in a review of that chapter. So that's what we're going to do in this video. So with that brief introduction, let's get started. And all I need to do is bring up the PowerPoint here to do that. There we go. Okay, so as I have mentioned in class, this chapter is about intellectual property, that is non-tangible property, and some other legal issues. Let's get going here. There we go, I hope. Yeah. Chapter starts out simply distinguishing between public and private law in so far as international matters are concerned. Public international law deals with the relationships between governments, includes treaties and various other agreements. Private international law relates to transactions between people and, more importantly, companies when they do business across borders. So these laws may flow from treaties, or there are other terms such as conventions and compacts and the like. And they can also flow from common practice. And in domestic law, we would call that common law. But it's based on practices that have become accepted and established over the years. There's a big item in international law, and that is extraterritoriality. That's quite a word, isn't it? But both the US and the European Union try to enforce their laws cross borders. And that can get you into some very sticky situations, but the US in particular has been fairly aggressive in enforcing labor laws, by way of example, as well as anti-competitive laws, particularly regarding price fixing and some other items that will come up later in this review. There will naturally be disagreements between parties that do business internationally, just like there are between parties that do business domestically. So the question is, how do you settle those differences so that whoever is not being treated fairly or correctly can get satisfaction in the courts? One way is to have a trial, litigation. And that's a very expensive way and takes a long time, very often. There are ways to get around that problem, one of which is to arrange for an arbitrator. So when you write a contract between two parties in different countries, you agree that if there's going to be a difference of opinion, some particular organization will be chosen to provide an arbitrator. Another possibility is a mediator. A mediator doesn't make a decision, just tries to get the parties to see each other's points of view. An arbitrator expresses an opinion. It's like a judge's verdict. And then, of course, if the two parties have agreed to follow the arbitrator's ruling, then the matter is settled. But when you're dealing with international relationships, even arbitrators' decisions may not be followed by a party in another country. It gets to be a little complicated. Of course, what you're looking for is performance of a contract. So let's say that one party agrees to deliver a certain amount of goods to another party in another country, accepts a down payment, but then doesn't deliver the goods. The customer wants to make sure that it gets, what it's paying for. There are other devices, and perhaps I should say organizations and agencies, very often part of the United Nations, that can help to mediate and arbitrate, sometimes through international treaties and the like. So, pardon me, I've got a radio on and I'm going to turn it off. I forgot to do that. The first item that we talked about on the prior slide was litigation. And here there's a real significant principle, and that is in a contract, any contract, not just international, you want to know which law is going to be used to decide who's right and who's wrong. In an international, a contract between parties in different nations, you're talking about which country's law will be the basis for a decision. And another issue, of course, is just what courts, in which countries will a dispute be argued in front of a court. And the cardinal rule here is you've got to have all this laid out in the contract. If you've got a dispute and these items haven't been laid out in the contract ahead of time, you've got a real messy situation. So you just have to have this. So there needs to be a clause that indicates which law governs and where disputes will be settled and where courts of which country. A performance contract simply states what each party will do to meet its obligations under the contract. The problem is that if one party, the two parties are in different countries, it's very difficult for the party in one country to get enforcement in another country. Now, the way that can be solved is through treaties and compacts and the like, where multiple countries agree to abide by certain rules. And if it's necessary, you could try a case in front of an international court. But again, the problem is if a party in one country doesn't agree with the court's verdict, how do you get that party to comply with the verdict? And the answer is that countries have to recognize that if they don't accept contractual obligations and international court judgments, then the next time a dispute arises and a company in its country is the one that's harmed, then they will wish that these arrangements worked better. The only way to make them work better is to accept these agreements as law in the countries that participate, and not permit companies in a separate country to get away with not performing, especially if there's been some kind of an arbitration or a court verdict that states that the company should perform. So we've got, among other things, the UN Convention on International Sale of Goods. That's a big deal. It's akin to the Uniform Code of Commerce that is used in the US by all of the states that selected or modified a bit, but pretty much the UCCs are the same in all the states. By the same token, the Uniform Convention on International Sale of Goods is the same in all the countries that have accepted this convention, and that's many countries. There can be arbitration, as I mentioned. There also are things called Incoterms, International Chamber of Commerce's terminology for what the obligations of a shipper and a receiver are insofar as doing the actual shipping, paying for it, paying for insurance, and the like. So here are some examples that are in the chapter. Free alongside ship means that the seller will get it to the ship, and then it's up to the buyer to get it on board and take it from there. CIF, the seller pays for costs of shipping and insurance, the freight, and freight to the foreign port. CFR is pretty much the same thing, except that the insurance is left out. Delivered at the frontier, DAF is an odd duck. You can read it. It has to do with Mexico and Canada, and it's just a strange arrangement, but it's used all the time. I've worked with several companies in Canada, one in particular that I've done a lot of work with, and it is a subsidiary of a larger corporation which has other subsidiaries in the United States. So this outfit in Toronto or Calgary, where they have operations, will get the product to a port or the border, the U.S. border, at which point somebody on behalf of the U.S. subsidiary has to accept it. And at that point, the U.S. subsidiary has to arrange for its shipment to the rest of the way to whatever operation the recipient has in mind. And sometimes the destination isn't with one of these operations in the U.S. In the U.S., this company has operations all over the U.S. And so, and it deals with customers that have operations even in other locations. And it may be that that shipment is designated for a customer's location rather than the subsidiary itself. So it just becomes really complicated. Long story short, especially when we're dealing with Canada, we've got this requirement for an agent or the company to receive the goods when they are cleared to cross the border, and then get them to wherever they're supposed to ultimately go. And it just adds paperwork, material handling. It's a real pain in the butt, and it's costly. Okay, so the point of this little slide is an important one, and that is that arbitration is much preferred over a court trial. It's faster. It can be confidential. It's a lot less expensive when you get down to the cost of lawyers and the like. The first point, I guess, is true in some cases. That may be that you don't trust the courts in the other country, but I think it's the last three items that are more important. And perhaps faster and less expensive, most important of all. So in this little slide simply summarizes some points that are made in the chapter that, in spite of the complexity and the costliness of international business, it's a growing part of industry, worldwide industry, so the folks who are involved in international commerce simply need to be aware of the legal environment of these other countries, which can vary substantially between countries. And sometimes managers make the assumption that the laws that apply to doing business in their country also apply in the same way in other countries, and then they're surprised to learn that that's not the case. Intellectual property is simply property that is not physical, like machinery and equipment and tools and buildings. Those are not intellectual property, they're tangible, physical property. Intellectual property is intangible, includes things like patents, trademarks, trade names, and copyrights. This, as I've mentioned in class, is a real issue, a source of issues, because we're still learning what intellectual property is. But you're aware that some countries or agents of countries have broken into computer systems of companies in this country and government agencies as well. And so when this hacking goes on, it's possible to steal the identities of many people, to steal trade secrets, formulae, methods of manufacturing, and so forth. And when the thief gets this information, they can use it to make products and profit. So they're stealing our money. And this has become a major issue. If you watch the news, you've heard about many cases where governments and agents in other countries have stolen intellectual property of U.S. banks, U.S. retailers, and the U.S. government. And so exactly how to deal with this is still a matter that is in development. But it's becoming a very, very critical. You can steal intellectual property without having to carry it away in a truck. Or, you can steal it simply by knowing it or capturing it electronically. Patent standardization is one way. And by that we mean, dealing with patents the same way across borders. So there was way back when some conventions on such matters. The International Convention for the Protection of Industrial Property has been signed by 173 countries. The European Patent Organization is there are today 28 countries in the European Union, and apparently, according to this slide, 27 of those 28 have signed on to it. The World Intellectual Property Organization oversees some 24 treaties through the auspices of the United Nations. This last one, TRIPS, trade-related aspects of intellectual property, is probably the one item that has received the greatest attention in the last couple of years. And what it represents is an attempt to define exactly what intellectual property is and how it's to be treated in trade matters. And then we get to anti-counterfeiting. You can see there's an agreement that was proposed when this book was produced. But anti-counterfeiting laws in this country and other countries actually differ a bit. What is hoped for is uniformity there. Little note at the bottom of the slide, and that is that smaller countries that have smaller businesses that are evolving, want to take advantage of new knowledge and not have to pay for it. They would prefer to see patents and other protections shortened from 15 to 20 years for a patent to 5 years. That is not a concept that companies in mature countries are going to accept. So we have various means of trying to protect intellectual property in the form of trademarks, trade names, and copyrights. You can see that the concepts are referred to in the context of the approach to protection that we've just gone over. How do we get to standardization? Because if we can standardize these laws and conventions, then companies, no matter where they may be located, can understand how these issues are going to be treated, in various ports of call, in countries that customers or suppliers are located, and so forth. And as the slide acknowledges, this is a work in process, but we've got various items such as Jack's treaties, the EU's antitrust articles 81 and 82 of the Treaty of Rome, one of the first agreements like this. World Bank has some arbitration facilities. That agreement on the international sale of goods that we talked about earlier. There's another one on accounting and bankruptcy standards. And ISO, International Standards Organization, the IEC escapes my mind right now, but I've certainly done quite a lot with International Standards Organization. And ISO basically is a set of quality standards that require a stamp on products that go from outside the European Union into the European Union. And if that stamp isn't present, the product cannot get into the European Union. So it has become a pretty significant item. I think we'll come across that other item, IEC, in a later slide. Anyway, we have competition laws, U.S. antitrust laws. They're different from, the two are different. The U.S. laws, since we're in this country, the textbook points out that price fixing, market sharing, business monopolies, these are areas that are quite specifically and emphatically enforced. The U.S. applies its antitrust laws outside the United States. And there are civil and criminal penalties. European Union also applies their laws extraterritorially. However, it is less stringent, less demanding than U.S. law. The U.S. would prefer to see the regulations on antitrust and competition uniform. And the textbook authors suggest that maybe the World Trade Organization is where this could be accomplished. The problem is that the U.S. Right now, the Trump administration, has some differences with the World Trade Organization, primarily because of these tariffs that the Trump administration has put on Russia and China. The WTO in general terms is not very favorable to tariffs. It tries to promote even terms of trade worldwide. Tariffs, of course, make the terms uneven, and that is contrary to the philosophy of the World Trade Organization. So we have other obstacles. You know, one set of obstacles, of course, is just the kind of regulations that we put on products coming into this country and leaving it. So it could be legal, regulatory, it could be political. On the other hand, there are various non-specific, non-quantitative limitations on what goes in out of the United States, and more importantly, what comes in. So it could have to do with packaging, could have to do with health, could be that there's something in regard to patent and trademarks. And ultimately, there have been in the past voluntary export restraint or voluntary restraint agreements. So back in the 1980s, Japan was just killing us in the automotive industry, the 80s and the 90s. And they came up with huge ships into which they could fit hundreds of cars, thousands maybe, but hundreds anyway. And when you saw one of these ships with all the vehicles on it, you just couldn't believe your eyes. And so they would land in California, come into the ports of California and unload these thousands of vehicles. And of course, the American auto manufacturers were just fit to be tied. Not least of which was because the Japanese cars were of better quality. So it got to the point that the auto industry wanted the government to put tariffs, quotas, and quotas, limits on what could come into this country as a car. Finally, the Japanese realized they'd better do something about this on their own, or they would suffer serious hardships. So they voluntarily restrained the number of vehicles that of various categories that would be shipped from Japan to the United States. And the U.S. thought that they had pretty much won that round, only to find out later that what the Japanese did was start building plants in the United States and proving that they were better at manufacturing cars than the Americans. Only now they could afford to build more expensive upscale cars and capture large shares of those market segments as well. So in the end, the voluntary restraint agreement turned out to be to Japan's favor rather than America's. And if you take the same thing in reverse, by the way, you get a voluntary export restraint. And that is specifically what Japan did. It agreed not to export so many, and particularly not to export them into the United States. Okay, tort, I imagine you've heard about in your business law course. And again, these simply refer injuries to, and the tort laws or common law evolve over time, and precedent makes a great deal of difference. In particular, product liability can be a serious matter. So if I used to have a client that made forklift trucks, heavy equipment, real heavy equipment. And if the forklift starts to go downhill and it's got a load on it, it can tip over and somebody can get seriously hurt. Now, was that the fault of the manufacturer or the idiot that drove that forklift down the hill with a load on it? And the answer is the latter. But the manufacturer can be sued for making a product that didn't stop itself at that point, that didn't have the necessary safety precautions. And so there can just be tremendous damages. Now, again, what if that forklift were made in Japan or Korea or Germany and brought into the United States, and the company or person who was damaged, maybe the company's using the machine and it damages some property at the location where it's working, and the property owner wants to sue somebody. Does it sue the contractor, which may have limited financial resources, or the manufacturer, which has greater financial resources but is located in another country? And there you go. So there are different approaches, different types of laws in this case. Some apply strict liability. If the tractor tipped over, then it doesn't matter whether anybody was hurt or not. It didn't perform the way it should have. And elsewhere in the world, the question is, well, did anybody get hurt? Was this machine the state of the art? Is it a new kind of concept that's being developed and it's the best that anyone can buy? Have there been adequate warnings given to the users and the buyers? So it's a tricky part of the law because there's so much money, so the damages are potentially huge. And for that reason, some manufacturers in other countries have stayed out of the U.S. That is less and less the case. If you live here in North Carolina and you drive up and down the highways that lead into where our campus is located, you can see equipment manufactured by Komatsu, a big Japanese competitor of Caterpillar, for instance, and lots of others. So as time passes, I don't think these laws have kept so many manufacturers out of the U.S., but they still require a whole lot of legal protection and legal work to make sure that a supplier can avoid being seriously damaged. Another area where another industry where the damages can be really large is in the medical and pharmaceutical industry. So here we have this point that I was mentioning earlier. The U.S. is a pretty strict enforcer. For that reason, liability insurance premiums are high. The caps on damages don't exist. A lawyer gets paid if he wins. A defense lawyer gets paid even if he doesn't win. Juries can hear these cases and sometimes will impose very harsh penalties and tend to be sympathetic to the plaintiff. Outside the U.S., it's a little different. State-of-the-art concept here, and developmental risks refers to EU language. There can and are caps on damages. If you're a plaintiff and you sue somebody for making a bad product and you lose, in European countries, you're obliged to pay the defendant's legal fees. And boy, does that really reduces the amount of these cases. In this country, people can bring a lawsuit for whatever reason, and if they lose, they don't have to pay the defendant's legal fees. But in Europe, you'll probably have to. And again, the case is not held, or the case is not tried before a jury, but rather a judge, who can be sometimes more objective. So then there are just some points here. Ignorance of the law is no excuse. The laws in other countries just are not the same as ours. If you happen to be accused of breaking a law in another country, your country may not be able to help you. In the U.S., we've got one rip-snorting chunk of law called the Foreign Corrupt Practices Act. And it deals with payments to government officials and bribes and so forth. It's nasty if you're accused. Usually the accusation will be by the U.S. Justice Department or an agency of the government. If you're found guilty, the penalties can be severe. But the question really is, what is a payment to a foreign government or a bribe to a government official or a buyer in a corporation? And so-called grease, and grease really comes down to marketing expenses that are intended to make a favorable environment, to make the conditions in which a U.S. seller does business with a foreign buyer favorable. It could involve conferences, conventions, maybe trips to nice locations where they have meetings and so forth. But what if it's just a free trip where you're giving a buyer's family an all-expense, 10-day vacation to Tahiti or something, and there's no business involved? Well, now you've got a problem. That's probably a Corrupt Practices Act under the Foreign Corrupt Practices Act. The responsibility is the management of the supplier in this case to know or have reason to know that such behavior is going on. Again, I think the most important point there are 2 points here. One, this is a real law with real teeth and real pain if you're caught violating it. The second is that it's complicated as hell and not perfectly clear. It really depends upon the attitude of the Justice Department folks who are looking into the matter and the clarity of the issue. And very often the issue is just not clear. We've got other anti-corruption statutes. We've got the UN Convention Against Corruption, and then the United Kingdom Bribery Act. And there, the the implementation of this law is less emphatic, and it's as the last bullet indicates, there's a lot of uncertainty about what qualifies as management's procedures and the adequacy of those procedures to prevent bribery, and how broadly to interpret the company's association with bribe payers. But there are penalties, and the UK, like the US, attempts to enforce this law extraterritorially. So there's that term again. Here's a little indication of the bribe payers index, where the higher the score, the more likely you are to find bribe paying. And this index is given to us from 1999 to 2008, virtually a decade ago. So to get the more recent version, you would have to go to the agency that produces this thing, which is Transparency International. There also is a difference in accounting laws between countries. The standards for preparing financial statements do differ between the US and other countries. In the EU, there's the International Accounting Standards Board and International Financial Reporting Standards, IFRS. And that's different. The IFRS is different from Generally Accepted Accounting Principles. And so you could read financial statements in one country that were prepared in another country in order to decide whether the company that you're looking at is creditworthy. It's because these accounting standards differ. Again, you've got to have somebody who can appreciate those differences and knows how to analyze a company's financial condition correctly, and condition, in particular, its financial condition in the country where the business is being done. And we won't concern ourselves with this global debate anymore, and so I will stop the sharing. This is a nice chapter. It's not difficult. Shouldn't take you too long to read it, but the material in it is quite relevant to doing business internationally. So I hope you will read it carefully. If you find yourself doing business internationally at some point, what you learned in this chapter could be useful to you. So with that, I'll try to end this meeting and see you soon for a review of Chapter 8. Goodbye.